All right, we should be good to go. Back in the building. Y'all know what to do. Let me see if we are good. Everybody should be able to see me. Y'all go ahead and drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. Oh, I know what I forgot. I forgot to put the chat up. Oh my goodness. This is my first time live streaming, guys, so y'all will have to give me a break today. Hopefully everybody's doing well. It's good to see everyone in here. Let me double check and make sure we got this chat going right. I see a couple of 1s in the building. Good to see y'all in here. Let me get Amy's message up here right on the show. Boom, we should be good to go. Thank y'all for dropping the 1s in here, because y'all know we be struggling sometimes. Welcome, y'all. Welcome to another YouTube live stream and another episode of the ClassE Morning Show. I'm your host, ClassE, at patreon.com/ClassEbeats. By the way, the link is in the description as well as in the pinned comment in the chat. What a crazy show we have today. One of the reasons that I was a little delayed in getting started was because we had so much breaking news coming out. We've got Brian Walshe. He actually took a plea, partial plea today, which is insane. Karen Reed, she's finally officially fighting back and filed her first lawsuit against all of them. I couldn't believe this. Against Proctor, Yuri, Tully, Brian Albert, Nicole Albert, Jennifer McCabe. And we are going to be the first to report it here on this channel. So y'all join the right place. We're also going to talk about some news here in Atlanta, as well as the McCabe's and the Alberts fighting back and filing their own lawsuit. This is going to be a wild one today. I'm super excited for the show. Hopefully y'all are too. But before we get started, I got to say what's up to the people, man. Thank you and shout out to everyone who's in here, the amazing people who make this show and this community what it is. Shout out to my awesome, amazing Amy. Always doing awesome and amazing things. We got Les Cleaver in here, Liz in the building, Mr. Brown, Kara Hampton is back at it. We got Valerie is in here, Kel Bell, the honorable attorney Kel Bell. Always good to see you. It says good morning. So glad I'm able to join today and see the CEB fam. Freedom Ring is up in here too. Good to see you, Freedom Ring. Thank you for stopping by as always. And I'll be saying good morning and what's up to y'all as we go throughout the show as well. This is going to be a crazy one. We've got so much breaking news to get to. I'm not going to ask you all for much, but the one thing I do ask is that you like the video on your way in. Likes are free, helps the channel continue to grow. Let's see how the algorithm know that y'all are enjoying the show, and it shares the video, the channel, and this live stream you're on right now with more people. So thank you again to the nearly 600 of you that have liked the video so far. I appreciate y'all. Thank you guys for making the show the place that it is, for continuing to support that way. Also, if you're feeling extra generous, you can share the video as well. Just click the share button. It's also got arrow curved and pointing to the right. You can share it to X, Instagram, Facebook, and even your group chat. So I know some of y'all do that. I see a lot of you sharing over on X as well. And if you're feeling extra especially generous, you can drop a super chat. I will be reading super chats as we go throughout the show. I know so many of y'all like to super chat and support the show by going the extra mile as well. So thank y'all for that. Let's go ahead and actually get into our first topic. I've got to get this updated because I wasn't even ready for this Brian Walshe topic today. But this is absolutely insane. So we're going to go ahead and get into it again. If y'all are ready, we're going to be talking about Brian Walshe and what is going on with this trial, because it gets insane. I don't think I even have a picture of Brian Walshe, which means we're probably going to put Judge Whitaker up there, or maybe we should put Karen Reed because they're connected in some ways. So if y'all haven't been following this Brian Walshe trial, we actually did a couple of videos on it, and I'm going to be dropping some videos about Brian Walshe today, kind of giving you the full story and the entire background. But when it comes to Brian Walshe, he is now looking at facing a murder charge. And there's some breaking news about Brian Walshe that just came out in this murder trial, because Brian Walshe is actually changing his plea. Not only is he changing his plea, but he's pleading guilty to 2 of the counts on this indictment. Now, he did this moments, really less than an hour before jury selection was to start in this trial, which is scheduled to start in a couple of weeks. So we're actually going to go to this breakdown from News 10 in Boston, and then I'll take you guys to the actual coverage, to the moment where Brian Walshe said he's going to plead guilty, and we'll talk about those 2 counts as well. Check it out.
And we were talking about what we've learned. Perhaps the headline of everything we just learned is that Brian Walshe has now pleaded guilty to counts charge 1 charge 2 and
Crazy.
charge 3. The first indictment was, or the second indictment was the intimidation of a witness, juror, police, or court official, essentially the fact that he misled these officers. This third, Michael Coyne, is the one I want to focus on, because essentially we heard the ADA there say that from January 1st to January 8th, the defendant, Brian Walshe, willfully conveyed away the body of Anna Walshe into dumpsters and garbage receptacles across Massachusetts. He conducted online searches and did research and disposed of the body, to which the judge repeated those facts back. And Brian Walshe, she said, "Did you do that?" And Brian Walshe said, "Yes, Your Honor."
Insane.
Michael Coyne, what does this mean for his case moving forward?
Well, now that evidence would be admissible that he's disposed of the body, so it changes how he would defend the case. Now, what he admitted, really, the evidence was pretty strong and supportive and likely would have been convicted.
Right.
The Internet searches, the Home Depot video, the tracking device he wears on his ankle from a previous criminal case showed that he went to all these various dumpsters in that time period. So what he's admitted, in essence, we'd call it's akin to giving them the sleeves off his vest. He's admitting what they likely could have proved and holding his defense on the major charge, which is the murder charge.
Now, the crazy thing with this is, if he's saying he's pleading guilty to moving the body or taking the body away or moving or dismembering the body even, why would they think a jury could possibly find reasonable doubt that he absolutely was the one that murdered her? I don't know.
The problem is that he's now acknowledged that he's disposed of the body, and so his choices as to how to defend the rest of the case are somewhat limited. He's either going to argue suicide, the third-party culprit defense. I think those are the most likely here. And the question is, why would he assist with the disposing of the body if he had nothing to do with her death?
Okay, Chief Legal Analyst Michael Coyne is joining us right now. If we pop up the full screen again, as this breaking news has just come in the last hour, as he changed his plea, 2 of the charges against him, intimidation of a witness, juror or a court official, and disinterment of a body. What does this do for the prosecution now, Michael? Obviously, the defense has a different way of approaching this now that they've gone on 2 different charges. For the prosecution, how much does this change for them?
Well, it gets them 90% home. I mean, and they're not going to walk away with not guilty straight across the board on serious charges, because one of these charges he could be away for decades that he's already acknowledged. But what he's trying to do is save his life at this point and not have to spend the rest of his life in prison. And so what it really means is, for the prosecution, is already they've got to win. The question is, can they solidify their case and prove murder beyond a reasonable doubt? I think what's interesting, too, as a development here, is in order for him to continue to defend the case effectively, he may now intend to take the stand, because the only person who could really explain why he would participate in the cover-up and not the murder would likely be him. And so it's kind of interesting that are we going to see the defendant actually testify in this case to support what may be left of his defense? And
that
that's
would be
always
crazy.
A dangerous move for a defendant to do, although the juries like to hear what the defendant's side of the events actually are.
All right, so now that we heard that, I want to know what you all think about this. I mean, obviously, just being someone who would be on the jury, they're going to know this. They're going to find this out. And if I heard this as a juror, I'm going to be like, man, hey, why are we even here? This should be an open and shut case. So I want to know what you all think about this in the comments in the chat. Let's go ahead and go to the court proceedings where this actually took place. And the judge said, hey, man, you sure you want to do this? And he admits to everything. Here we go.
Okay. Yeah. We'll good.
Everyone all set?
Yes, Your Honor.
Thank you.
May I proceed, Your Honor?
You may.
Mr. Walsh, can you please stand?
Mr. Walsh, do you wish to offer a change of plea on docket number 2382CR91002, which charges you with intimidation of a witness, juror, police, or court official, and 003, disinterment of a body? Do you wish to offer a change of plea from not guilty to guilty?
I do.
Could you raise your right hand, please? Do you solemnly swear to make true answers to such questions as should be put forth to you by the court, so help you God?
I do.
Thank you. Could you please take the witness stand?
Actually, you know what I'm going to, this is an odd configuration. I don't want counsel standing. So I'm going to let you stay right there, sir. You understand you're under oath?
I do.
All right. Why don't you be seated and you can have the benefit of your counsel at the ready right there.
Okay.
If y'all don't
Mr.
think
Walsh,
the jury,
as you know,
if y'all don't think the jury is gonna know Brian Walsh pled guilty to 2 of these counts, I mean, come on. I know we're naive, but we're not that naive.
Mr. Walsh, as you know, my name is Diane Frenier. I'm the judge that's presiding over this trial, and I'm an associate justice of the Superior Court in Massachusetts. I understand from your lawyers that you wish to change your plea to guilty to counts indictment 002 and in 003. And before I can accept that change of plea to guilty to those 2 indictments, I need to ask you some questions to make sure that your decision to plead guilty is made voluntarily and that you understand the consequences of pleading guilty to those 2 offenses. If at any time during the course of this colloquy you don't understand something that I am saying to you, just let me know by letting your attorneys know. Let them consult with you. And equally, if I don't understand something that you're saying to me, I'll ask for that further clarification. Do you understand, sir?
Yes, Your Honor.
All right.
Wow.
Can you please state your full name, sir?
Brian Walsh.
All right. And Mr. Walsh, do you have any difficulty speaking or understanding English?
I do not, Your Honor.
How
Are
old are
you
you,
drunk?
sir?
I'm sorry, I missed that.
Sure, I'll try to get into this microphone. How old are you?
50.
And what's your exact date of birth?
January 31st, 1975.
Where were you born, sir?
Boston.
Are you married?
Yes.
Why did he pause there? Perfect. Hey, I need my body language experts to get in on this one, and specifically Amy, because she's the chief body language expert here on the channel. Amy, why did he pause? I shouldn't laugh. Why did he pause before he answered if he's married or not? Kind of crazy. Anyway.
Are you married?
Yes.
Is he married?
Do you have any children?
Yes.
And what are their ages?
9, 6, and next month, Brian will be 5.
How far did you go in school?
College, some college.
That was like a year and a half or 2 years.
Oh, yes.
And where did you go to school?
Carnegie Mellon,
What did you study?
business and computer science.
As an adult, have you had full-time employment?
I've had my own businesses,
And in what kind of businesses?
mostly consulting.
Okay. I need to ask you some personal questions. I'm going to ask you those questions now. Have you ever in the past been treated for any mental illnesses or conditions?
Yes.
Tell me about them.
Depression.
Yeah, it's sad, man.
And are you aware of whether anything else other than depression?
That was the main thing.
All right. And are you presently aware of whether you have any mental illnesses or conditions, to include depression?
No.
Are you taking any medications?
No.
In the last 24 hours, have you taken any drugs, legal or illegal?
No.
In the last 24 hours, have you consumed any alcohol or alcoholic beverages?
No.
Is your mind clear here today?
Yes.
Tell me in your own words, sir, why are you here?
I'm here to plead guilty.
On those 2 counts?
Yes.
And you understand that your trial's starting today?
Yes.
On the first indictment? All right. To defense counsel, have you had any difficulty communicating with your client?
No, Your Honor.
And do you believe that he has understood the advice
There
that
you go.
you've provided to him?
Same.
Yeah, but he didn't pause on anything else. Are you married? He's like, yes.
So at this time, I'm going to go over what's called the waiver of rights. And at the end of it, I'm going to give you the form back that I believe you signed earlier today. Do you understand, sir, that by pleading guilty, that you're giving up your right to have a public, fair, and impartial trial as to each of the 2 indictments to which you're now pleading guilty, with or without a jury, to determine your guilt or innocence?
I do, Your Honor.
And do you understand that if you went to trial, you wouldn't have to prove anything? For example, you never have to take the stand to testify. You would never have to call any witnesses. No jury could ever hold it against you if you did not present any evidence at all. Instead, it is the Commonwealth that has the burden to prove you are guilty of each of the offenses and each element of those offenses beyond a reasonable doubt. Do you understand that?
I understand, yes.
You have the right to be tried by a jury of 12 people selected from your community, and you would have the right to participate in jury selection. You could not be found guilty unless the Commonwealth convinces all 12 jurors that you are guilty beyond a reasonable doubt, and they unanimously agree you are guilty. Do you understand?
Yes, Your Honor.
You also have the right to be tried by a judge instead of a jury. And again, the judge couldn't find you guilty unless the Commonwealth presented evidence sufficient to convince the judge beyond a reasonable doubt that you are guilty of the charge. Do you understand?
Yes.
Do you understand that if you went to trial, you would have the right to confront your accusers and any other witnesses that may testify against you by facing them and having your attorneys ask questions of them?
Yes, Your Honor.
And do you understand that if you went to trial, you would have the right to call your own witnesses, present your own evidence, and if you wished, even testify on your own behalf? Do you understand that?
Yes, Your Honor.
Do you understand that by pleading guilty here today, you're giving up your right to pursue any arguments or motions that your attorneys may have made or filed on your behalf in this case, and that may include motions to dismiss and motions to suppress, as well as your right to appeal any rulings or decisions that the court may have already made in this case?
Yes, Your Honor.
And are you willing to give up each of those rights?
Yes, Your Honor.
Pass that to the defendant. Sir, if had the court officer pass to you defendant's waiver of rights, have you seen that form before?
Yes, Your Honor.
And did you read that document or have someone read it to you?
Yes, Your Honor, I read it.
Have you reviewed it with your attorneys?
Crazy.
Do you understand it? Do you understand what's contained on the waiver of rights form?
I do, Your Honor.
You understand that that form sets forth in writing what you and I have just been discussing a moment ago in terms of your willingness to waive your constitutional and statutory rights and plead guilty to the 2 indictments.
Yes, Your Honor.
Is that your signature at the end of the document?
Yes, Your Honor.
And did you sign that voluntarily?
Yes, Your Honor.
So what's he gonna get? What was the
By
plea?
signing that form, you're confirming to me, sir, in writing that you are aware of the rights explained on the form, that you understand them, and that you voluntarily waive them. Is that correct?
Yes.
Do you understand, sir, that you are pleading guilty to the following 2 indictments? Indictment 002, which charges willfully misleading a police investigation, a criminal investigation, in violation of Massachusetts General Laws, Chapter 268, Section 13B. And in indictment 003, you are pleading guilty to, while not being lawfully authorized by proper authorities, willfully conveying away a human body or the remains thereof in violation of Massachusetts General Laws, Chapter 272, Section 71. Do you understand?
Yeah, and basically that means that he illegally moved the body or transporting a dead body without permission.
And that
is what that means.
Yes, Your Honor.
And have you talked to your attorneys
So he
about
moved
each
her
of
body.
these two indictments?
Yes, Your Honor.
Has counsel
Her dead body.
explained the elements of each of those two indictments that the Commonwealth would have to prove beyond a reasonable doubt?
Yes, Your Honor.
Do you understand each indictment?
I'm sorry, what did you?
Do you understand each indictment?
Yes, Your Honor.
And to defense counsel, have you explained the elements of each of the two offenses to your client?
Yes, Your Honor.
I'm going to ask that the assistant of the Commonwealth, whoever wishes to do it, would tell me what the maximum and minimum sentences are. And I don't believe there are any mandatory minimum sentences, but you can tell me if there are.
There are no mandatory minimum sentences, Your Honor. The maximum sentence on count 2 is 10 years unless the investigation is into a capital offense, and then it is a 20-year sentencing enhancement, up to 20 years.
Wow.
On count 3, it is up to 3 years in state prison.
Wow. 3 years for moving or illegally transporting a body.
Mr. Walsh, did you hear the maximum possible sentences for the charges that the Commonwealth just recited?
Yes, Your Honor.
Max of
And do you
13 years.
understand those maximum potential offense charges, sentences?
Yes, Your Honor.
Do you understand that I have the authority to impose consecutive sentences on indictments, meaning, for example, that the sentence on the second indictment would begin only after you completed your sentence on the first indictment?
Yes, Your Honor.
Do you understand that if I impose a period of probation, you will be subject to the terms and conditions imposed, including not committing any other crimes and reporting to your probation officer?
Yes, Your Honor.
If you should later be found in violation of any of the terms or conditions of your probation, a judge could sentence you up to the maximum penalty allowable by law for any of the charges on which you have been found in violation of probation, and would be required to sentence you to any mandatory minimum penalty required by the law.
Yes, Your Honor.
Do you understand what I just explained?
Yes.
Pleading guilty has certain implications for you, and I'm going to go over those implications with you now. First is DNA testing. By pleading guilty to these two indictments, you will be required by law to submit a sample of your blood, hair, and/or saliva, and that sample will become part of the Massachusetts DNA database. You will be required to pay for the cost of collecting, preparing, and processing that sample unless you are determined to be indigent, and failure to comply with this law will subject you to separate criminal penalties. Do you understand?
Yes, Your Honor.
Are you still willing to plead guilty?
Yes, Your Honor.
I know earlier in the colloquy this morning you told me that you were born in Boston, and I have no reason to doubt that. But the law mandates that I give you warnings with regard to immigration consequences, and I'm going to give you those immigration consequences now. If you are not a citizen of the United States, you are hereby advised that my acceptance of your guilty plea may have the consequence of deportation, exclusion from admission to the United States, and denial of your naturalization request, all pursuant to the federal laws. Further, if the offense to which you are pleading guilty is under federal law, one that presumptively mandates removal from the United States, and federal officials seek your removal, it's practically inevitable that this conviction will result in deportation, exclusion from admission to the United States, and or denial of your naturalization request, again, under those federal laws. Do you understand what I just said?
Yes.
Has your attorney advised you of these consequences if you are not a citizen of the United States?
Yes, Your Honor.
And understanding that, do you still wish to plead guilty?
Yes, Your Honor.
Wow.
Because the sentence for count number 2 could be a state prison sentence of 3 or more years, I'm now going to give you what's called the habitual offender law warning, which I'm required to give you. Here it is.
What is that?
If at some time in the future you are convicted or plead guilty to a third or subsequent offense that is within the category of offenses covered by the statute, then 1, you may be imprisoned in state prison for the maximum term provided by law for such third or subsequent offense. 2, your sentence could not be reduced or suspended. And 3, you may be ineligible for probation, parole, work release, or furlough, or to receive any deduction in the sentence for good conduct. Do you understand what I just said?
Yes, Your Honor.
And understanding what I've advised you with regard to these sentencing consequences, are you still willing to plead guilty to the 2 charges?
Y'all
Yes,
think
Your
he's
Honor.
going to get the max? I don't think so. And if he does, they'll be concurrent.
All right. I'm now going to ask the Assistant District Attorney to summarize the evidence that would have been presented against you by the Commonwealth if you went to trial in this case. And I'm going to ask, sir, that you listen carefully, because when the ADA is finished, I'm going to ask you some questions about the facts that the ADA has stated.
Give a quick summary, brother.
Your Honor, regarding count 002, misleading police in violation of Mass General Laws, Chapter 268, Section 13B. On or about or in between January 1st to January 8th, 2023, Mr. Walsh did willfully mislead police officers with the intent to impede, obstruct, delay, prevent, and otherwise interfere with the criminal investigation into the disappearance and murder of Anna Walsh. The defendant first misled the Cohasset police in the morning of January 4th, 2023, when after he had reported his wife, Anna Walsh, missing. He stated to a Cohasset police officer that Anna Walsh had left the Walsh residence at 516 Chief Justice Cushing Highway in Cohasset on the morning of January 1st, 2023, by taking an Uber or Lyft to Logan Airport when returning to Washington, D.C. for a work emergency. The defendant then continued to mislead police officers. When he made additional false statements about Anna Walsh being alive and voluntarily leaving the Walsh residence, as well as when he detailed his whereabouts on January 1st, 2023, to Cohasset police and Massachusetts State police officers. The defendant continued to make false statements when the police officers from these agencies met with him, including on the evening of January 4th, on January 5th, January 7th, and January 8th. In January of 2023, the Cohasset Police Department had approximately 20 full-time police officers, including 2 detectives. The Cohasset Police devoted all available resources in an attempt to find Anna Walsh. They requested assistance from other departments and agencies. And on January 6th, the chief of the Cohasset Police Department conducted a press conference seeking help in locating Anna Walsh. As a result of the defendant's false and misleading statements, law enforcement agencies and police officers took many actions, which had a heavy financial and emotional cost. These included the Cohasset Fire Department searching a swimming pool at the Walsh residence. Teams of police officers from multiple agencies and departments, including a K-9.
There's no way that Ryan Walsh is going to reveal where she is.
Teams
No
participating
way.
in large-scale canvass of the area around the Walsh residence during inclement weather. D.C. Metro Police attempted to locate Anna Walsh in Washington, D.C., and Massachusetts police officers, including Cohasset Police, Massachusetts State Police detectives, and other units from the Massachusetts State Police traveled to Washington to search for Anna Walsh in a result of the defendant's false statements. The defendant's conduct was willful. His statements impeded, obstructed, delayed, and otherwise interfered with the criminal investigation, and the delays resulted in contents of dumpsters in which the defendant had disposed of Anna Walsh's remains being incinerated.
Why don't you pause there? We'll deal with count 2, and then we'll go to count 3.
Yes, Your Honor.
All right? So, Mr. Walsh, did you hear what the Assistant District Attorney just said with regard to the statement of the offense conduct for indictment 002, misleading police?
Your Honor, if I may, Mr. Walsh is prepared to admit to the recitation of facts with respect to the indictment that the government just read, insofar as it alleges he did impede and obstruct the criminal investigation into the disappearance of Anna Walsh. We obviously object, and he's not admitting to and murder. The second portion of the facts that the government just read that we would take issue with is the last sentence, and the delays resulted in the contents of the dumpsters into which the defendant had deposited Anna Walsh remains being incinerated. Insofar as the rest of the facts, he's prepared to admit.
All right. Mr. Walsh, you just heard what Attorney Porges said, sort of the insofar as. It's another way of saying it limited to this. And you heard what your counsel just said. Understanding those limitations as just articulated by your counsel, did you do or join others in doing those acts?
Yes.
Do you understand that by pleading guilty that you're admitting to the facts described as revised by your counsel are true?
Yes.
Are they?
Yes.
Mr. Walsh, did you in fact willfully mislead various law enforcement to include members of the Cohasset Police Department and the Massachusetts State Police with the intent to impede or interfere with the criminal investigation of Anna Walsh's disappearance?
Yes, Your Honor.
All right. Moving to indictment number 3.
Thank you, Your Honor. Willfully conveying a human body in violation of Mass General Laws, Chapter 272, Section 71. on or about and in between January 1st and January 8th, 2023, the defendant Brian Walshe willfully conveyed away the body of Anna Walshe or the remains thereof from the Walshe residence at 516 Chief Justice Cushing Highway in Cohasset by conveying and disposing of Anna Walshe's body without a license or lawful authority or the remains thereof into dumpsters and or garbage receptacles in eastern Massachusetts. The defendant's actions were willful. Anna Walshe was not a stranger to the defendant. She was the defendant's wife and mother of his 3 young children. The defendant conducted internet searches into disposal of the body, researched locations of dumpsters, and then traveled to those locations. In disposing of the body of Anna Walshe, the defendant did not comply with the law.
That's crazy.
Thank you. Sir, did you hear what the Commonwealth just alleged it would prove the case went to trial with regard to indictment number 3?
Yes, Your Honor.
And did you do those things or join others in doing those acts?
Yes, Your Honor.
Do you understand that by pleading guilty to today, you are admitting the facts described just now by ADA Connor?
Yes, Your Honor.
Mr. Walsh, did you in fact willfully remove or convey the body of Anna Walshe or her remains, not being lawfully authorized to do so?
Yes, Your Honor.
That's it.
Do you now plead guilty to these indictments willingly and voluntarily?
Yes, Your Honor.
Has anyone threatened you or forced you in any way to plead guilty to these 2 indictments?
No, Your Honor.
Has anyone promised you anything in return for your plea of guilty to these 2 indictments other than the terms of the plea agreement that we discussed? Excuse me, there's no plea agreement. That's what happens when you keep reading from the book, and you shouldn't. Has anyone promised you anything in return for your plea of guilty to these 2 indictments?
No, Your Honor.
Have you had enough time to discuss your rights, your case, your defenses, and the possible consequences of your guilty plea with your attorney?
Yes, Your Honor.
Wow.
And do you feel that Attorney Tipton and Attorney Porges have acted in your best interest, that he and she have fully, fairly, and adequately represented you in this case?
Yes.
Are you confused in any way by any of the questions I've asked you today?
No, Your Honor.
As I understand it then, sir, you're pleading guilty to these 2 indictments because you wish to plead guilty because you are guilty. Is that correct?
That is correct.
Counsel, do you know, defense counsel first, do you know of any reason why I should not accept your client's guilty plea?
Nope.
Same question to the Commonwealth.
Your Honor, I'll be brief, but we had spoken. This is a non-negotiated plea with the Commonwealth, and we had some objections to it. But my concern was where the defendant equivocates on the factual basis. The Commonwealth read in that is one reason you should not take it. And the second is this count 3 revolves around the improper disposal of Ms. Walshe's remains. And the defendant, when asked his marriage status, said that he was married. And consequently, Your Honor, then that is not an accurate relaying of his current status to the court and could be invalidating the plea. So I believe he has to be asked that question again. And I believe that if he continues to say he's married,
so he
he's
paused.
Negating facts of count 3.
That is a great call out because I had an issue with that too. We had a conversation about it in the chat. Is he married really? Because if he's admitting to disposing of her dead body, then I guess now they could issue a death certificate. And so he's technically not married. But at this time, just because he's pleading guilty to moving her body, the law is insane.
Right, I'll give defense counsel an opportunity to speak with your client.
Your Honor, I apologize. I couldn't exactly hear what Mr. Connor's caveat was.
In response to one of the early questions I asked of the defendant, I asked him if he was married, and he said yes, he was.
He paused.
The Commonwealth was raising the point that if that were true, that it might negate proof of the disinterment, which requires a human body or remains. Do you want to speak to your client about that?
A moment, Your Honor.
Mm-hmm.
Interesting. Very interesting.
Your Honor, respectfully, I don't see this as a relevant or material issue. If the court wants clarification, I'm happy to approach sidebar.
Why don't we do that?
Okay.
Yeah, it's really strange to see that. Shout out to the Honorable Kel Bell in the building, because again, I mean, how will that go moving forward? What will that mean for this trial? How's that going to factor in even into the investigation? And this isn't him taking a plea deal. So I hear a lot of people calling for, oh, tell us where she is. Tell us where she is. He doesn't have to do that. He's just say, yeah, I'm guilty. And the judge is going to find him guilty. It's very, very strange. They're going to sidebar to figure out what they want to do here. Oh, we are in the Commonwealth, so we got to say sidebar. Pardon me. Got to get my Boston accent back.
Walsh, earlier today I asked you whether you were married, and you answered yes, you were married. Do you remember that?
Yes, Your Honor.
And is it correct that you were married to Anna Walsh for a period of time?
Yes, Your Honor.
And that under the law, death extinguishes marriage. It may not religiously or otherwise, spiritually, but under the law, when someone dies or when someone is dead, you can no longer be married to them. Do you understand that?
Yes. Yes, Your Honor.
And so are you married today?
Your Honor, if I may, insofar as previous discussions, for purposes of a successful plea colloquy and meeting the elements of the crime, he is acquiescing to the fact that lawfully he is not married today.
All right. You heard what your lawyer just said? Agree with what your lawyer just said?
Yes, Your Honor, I agree.
All right. Anything else that we need to cover?
That's why he paused.
All right.
It's like,
to the
am I
extent that
married?
the Commonwealth is objecting to the taking of the plea on other grounds, that is overruled. My job here is to make sure that I have a valid plea, and that means that the defendant is pleading guilty to the elements that the Commonwealth would have to prove beyond a reasonable doubt, and I have inquired sufficiently to assure myself that he has admitted to each of the elements of the two offenses of indictment 02 and 03.
Mm-hmm. And the judge is going to look it over.
So I know we discussed at an earlier point the issue of victim notification, and I'll ask on the record now for the Commonwealth. Has the Commonwealth advised the victims of this case of the defendant's offer to change his plea to guilty?
Yes, we have notified the victims, Your Honor.
And based on our prior discussions, I understand that the victims may wish to address this court prior to any sentencing of the defendant.
That is correct, Your Honor.
All right. And both parties that we've talked about this have agreed that we're not going to be sentencing the defendant today on the indictments that he's now pleading guilty to, correct?
That is correct, Your Honor.
Attorney Tipton, Borges? All right. And we'll give the victims a reasonable opportunity to address the court before sentencing, of course.
Thank you.
This is the weirdest thing I've ever seen. And we're going to have a conversation about this after this video is done. We'll have it with the attorneys in the community. But this is so odd because there hasn't been a death certificate issued that I'm aware of for Anna Walsh, which technically means Anna Walsh legally is still alive, which technically means he's still married. But if he's the one who murdered her and he's now pleading guilty to moving her dead body, then again, as I asked in the chat, and I'll ask the attorneys this, does this guilty plea of moving her dead body then supersede something that would be maybe like a death certificate? This is so strange. Is he legally married? I don't know. I mean, this is weird.
Your Honor.
But for the plea to be truthful, I'm sure this isn't the first time this has happened.
You understand, Mr. Walsh, that at the time that we do get to sentencing, that by law, I'm not bound to any recommendation that's made by the prosecution or your lawyers. You understand that?
Yes, Your Honor.
And that I may impose any sentence permitted by law up to the maximum allowable sentence.
We'll never know.
Yes, Your Honor.
Having considered Mr. Walsh's criminal history, the government's proffered evidence, I will later consider the victim's statements to the court for matters for sentencing. I find that Mr. Walsh has met the requirements to tender a plea to counts 2 and to counts 3. I make the following findings. I find that the defendant is not presently under the influence of drugs or alcohol, and that he hasn't reported that he's not presently suffering from any mental illness or condition, and that he's not presently taking any medications. I find that the defendant understands the nature of the charges and the consequences of his pleading guilty. I find that the defendant's change of plea to guilty with respect to each of the two indictments, 02 and 03, is made knowingly, willingly, intelligently, and voluntarily, and with the full knowledge of its consequences. I find that the defendant's change of plea on these two indictments to guilty is made upon and with the advice of competent counsel, and I find there's a factual basis in the evidence as has been summarized by the prosecution and limited by defense counsel on behalf of the defendant for each of the two indictments to which the defendant now pleads guilty. Accordingly, I accept Mr. Walsh's plea of guilty as to indictments 002 and 003. Anything else that counsel that we need to do on the change of plea?
We'll talk about it in a second.
All right. So let me turn to impanelment.
Okay, we're not going to get into all that. We're going to let the attorneys handle that. Let me know what y'all think about this in the comments in the chat. This trial moving forward is going to be wild because we're going to know that in the back of our mind, which again, the jury, they could possibly be aware of what's going on here as well. The jury has not been selected. They could have seen something come out about this breaking news. They might hear about it when they go home. Who knows? And maybe the jury today, maybe no one from the jury pool today gets selected, which means there's a whole day's worth of jurors that could be out there watching the ClassE YouTube channel right now that would hear this. Let me know what y'all think in the comments in the chat. And Amy's saying it right from what I'm seeing. Yes. Did the judge get it wrong? Amy says legally he's considered married unless and until one of the following happens. A court issues a divorce judgment or the state issues a legal death certificate. That's what I'm saying. Does a guilty plea supersede a death certificate? From my research, I'm seeing no. And I 1000% agree with Amy. And again, here's what he's saying he's guilty of. Conveyance of a human body in Massachusetts basically means illegally moving or transporting a dead body without permission. A dead body. That is a felony. So, for his plea to be truthful, that means Anna Walshe would have to be dead. For the judge to accept that, that would have to be for the judge accepting that Anna Walshe is dead and that her body was moved by Brian Walshe, which means now, I mean, wouldn't they have to issue a death certificate for this plea to be truthful? And if he answered, because otherwise he still has to answer, yes, I'm still married. Legally, he's still married. Where did I find this? I found the same thing Amy said. So a murder plea does not override a death certificate. The plea does not replace or override or act as a death certificate. A death certificate is a separate legal document issued by the medical examiner or state registrar. Obviously, even if someone pleads guilty to killing someone, they are still legally married until the state officially records the spouse as deceased. What is happening here? Where are our attorneys? I need y'all in here, man. We need some help with this. We're probably way overthinking it, but this is, I haven't seen anything like this before. Anna still needs to be officially declared deceased by the state. Once that happens, she is legally recognized as deceased. Only then does the marriage end by operation of law. So he's not even a widower yet. And Amy's saying exactly the same thing. A guilty plea does not dissolve a marriage. Even if Brian Walshe pleads guilty, admits to killing Anna, describes what happened and helps locate the remains, he is still legally married unless one of the two things happen. A death certificate is issued or a judge signs a legal divorce judgment. And then a medical examiner would still have to say or identify that this was Anna. So even if he said, yeah, I did it. I disposed of Anna's body. It's left. I left it here, here, and here. They go and get the body. They recover Anna's body. Then, and only then, could a medical examiner look at everything and say, okay, well, I found evidence that, yes, this is Anna. Because, I mean, God forbid, what if it's not Anna? What if it's somebody else? And then it turns out Anna's still out there somewhere. Yo, this is crazy. I never even thought about this. I did not think this plea was going to be this interesting, but shout out to y'all for sticking with me. You can see the smoke coming off of my head from trying to think this through. This is brilliant. It will be impossible for them to prove how / if she was murdered. I don't think it's brilliant because they got the motive. They got the man saying that they've got the man saying that he moved her body. So this seems like a more difficult task for the defense because now they have to show beyond a reasonable doubt. Let me say it this way, because the burden of proof isn't on them. The state is going to be able to easily show beyond a reasonable doubt that Brian Walshe was the one that killed her. And if now those charges are gone and it's just murder, how did they move forward with this? How did they move forward with this without bringing up counts 2 and 3? Apparently, they don't have to say anything about the plea to the jurors, correct? They don't know about this is what I'm hearing. Yeah, the jurors, come on. They're going to know. Guys, come on now. They're going to find out one way or another. I mean, jury selection is just starting. Are they in jury selection right now?
I left this uncovered. So. Has or has not proved beyond a reasonable doubt.
So again, guys, there are jurors right now sitting there waiting on their phones, watching the ClassE YouTube channel. I'm like, oh shoot. Let me see what that Brian was. Oh. Wait a minute, he pled guilty to the last 2 counts? Oh. Yeah. They shouldn't know, but they will. Yeah, this is crazy. Amy says, anyone else keeps hearing static or like there's a loose cord, or is it just me? Uh-oh. Hopefully not. Hopefully not. Thanks for the heads up. Y'all let me know. They don't know how she died, so how can they prove beyond a reasonable doubt? This won't come in. You do hear static? All right. How is it now? Do you guys still hear static? Let me go check and listen to myself. Let me see. Check. Then does the marriage end by operation of law? So he's not better. We're good. So he's not better. We're good. Okay. We should be good. All right. We made it. Thank y'all for the heads up. I don't know what was going on here. Sounds great. I do not have my phone close by. No. A little static, but not terrible. Okay. Where were we at? What were we talking about? They don't know how she died, so they can prove beyond a reasonable doubt. I mean, what are they gonna God, come on. Like every 30 seconds to a minute. Okay. Well, y'all just let me know. Thank you, Amy, for having my back. Let me know if you hear it again, and then we'll make some adjustments. But think about this for a second. Oh, and shout out to Melly. I forgot. Melly dropping the 5-bomb over there with the super sticker, saying we dropping the mic. Thank you for the support, Melly. I appreciate that. Thank you for showing love. Let's talk about this for a second, because this is I've never thought about this before, and I need some help from our attorneys in the community. From what I have seen on various channels, most say this is a good move by the defense. Okay, maybe. What does the state have? They have him buying a bunch of cleaning supplies. They have him on his iPad asking about how to dispose of a body and how long it takes for a body to start smelling. And all right, you said it happened again. All right, let me see. I think I may have fixed it. Y'all just let me know if you hear it again. So they have all this information, him buying the cleaning supplies. They have Brian Walshe Googling stuff on the iPad. I mean, they still have him finding out allegedly that she was having an affair with someone. All right, you've got the motive, you've got the means. And he was the last one to see her alive. He disposed of her body. I mean, I'll see how the defense argues this. That's the only reason I hate looking at this pre-trial stuff, because now I'm going to have that in the back of my mind as a juror, which probably a lot of the jurors will. And it's going to be hard to hear the rest of this case from the defense, because I'm like, well, if he moved the body, how else did she die? So unless the defense comes out and says, hey, he had all this stuff. Yeah, well, you can't prove that he was the one that Googled that on his son's iPad. Maybe his son was curious. I don't know who Anna was involved with. Maybe she was involved with some bad people. They were the ones that did it. Brian Walshe found her. He got scared. He disposed of her body because he didn't know what to do. And he knew all the signs were going to point to him being the one that did this. Yeah, exactly. Yes, he did not take a plea. He changed his plea. There's a difference. Yes, because he doesn't get a deal. He's just saying, all right, I'm guilty. Those are all evidence for disposal, not for murder. So this plea might have weakened the prosecutor's case. We'll have to wait and see. But none of that proves that he kills her. It works for TV or it works for the chat, but none of it proves he murdered her. Well, we still have to see the case that the state's going to present, because they may not even need it, may not have even needed that. We're looking at it from the innocent until proven guilty side, which I respect. But what evidence do they have to show that he did murder her? Plus, there's the crazy stuff about her and the FBI agent in Washington, D.C. There's reasonable doubt all over the murder. He is so guilty, but the plea has weakened the case a lot, y'all are saying. They cannot introduce either of the two charges he pleaded to, correct? Okay, y'all said the mic is good now. All right, wow. Crazy stuff. This trial is going to be interesting. Y'all know we're going to be following along with this trial, because this is crazy. Let's go ahead and get into Karen Read. He said he did it. He said he moved her body. He didn't say that he killed her. I mean, I don't know, man. I don't know. This is going to be wild. And I'm going to get rid of this here. And we're going to talk about Karen Read. We're actually going to look at the Karen Read lawsuit. We're going to be the first ones to cover this, which is crazy, man. Breaking stories is fun. We're actually going to get a little bit of an assist from, where are they at? Boston 25 News. Shout out to Ted Daniels over there doing the Lord's work. We're going to get into this, and then we're actually going to review the full Karen Read lawsuit here. And I've also got a clip I want to play for you guys as well from Alan Jackson. Let me skip ahead here and get to AJ's part. Shout out to Karen Read. Well, we'll let Karen Read play. All right, we should be good. Again, thank you to all 15,000 of you that are in here. Most of you have liked the video. If you haven't yet, please make sure you like the video, guys. I don't ask for much on this show, but I do ask and absolutely beg that you like the video, because likes are free. So y'all please make sure that you like the video on your way in, and we're going to go ahead and get into it. This is absolutely insane. Karen Read finally, as promised, is fighting back. And she just filed a major lawsuit against, and we're going to go through the lawsuit here, Michael Proctor, Sergeant Yuri Buchanan, Brian Tully, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins. We're going to talk about it here. Boston 25 is going to break it down for us, and then we're going to go through a full review of this lawsuit. Check this out.
We're also following breaking news in the Karen Reed saga. Reed has filed a sweeping civil lawsuit against members of law enforcement and people who testified against her in her murder trials. Let's get right over to investigative reporter Ted Daniel. Ted?
Hi, Ray. We just pulled the suit off mass courts a short time ago. It's huge, 46 pages. I'm still going through it now. Let's start with the defendants in this case. Reed is suing 3 members of law enforcement, former state police detective Michael Proctor, his then direct supervisor, Sergeant Yuri Buchanan, and MSP Lieutenant Brian Tully. 5 people who testified against Reed are also named: Brian Albert, his wife Nicole, Jennifer McCabe, her husband Matthew, and ATF agent Brian Higgins. Reed is seeking damages to recover damages from what she says was 3.5 years of being, quote, wrongly accused of John O'Keefe's death. This suit pulls heavily from Reed's defense in her murder trials. She alleges John O'Keefe was not hit by a car, but was actually killed inside the Albert home during a late night fight. O'Keefe was found with a massive head injury outside that home in Canton. Reed alleges people inside the house, quote, concocted a plan, unquote, to avoid and blame and, quote, frame her. As for law enforcement, Reed claims, quote, they permitted would-be witnesses to communicate with each other and coordinate their stories before any formal interviews, unquote, and, quote, allowed critical evidence to be manipulated in some instances and outright destroyed in others, unquote. Reed's suit comes one day after the McCabes, Alberts, and Brian Higgins filed paperwork stating their intent to sue her and her most aggressive supporter, Aiden Carney, a.k.a. Turtle Boy. Their suit calls Reed's proposed claims against them a vile work of fiction and a ploy to, quote, defame and wrongly malign them. Still going through all the paperwork, and we'll be updating this story throughout the day. I'm investigative reporter Ted Daniel, Boston 25 News.
Shout out to Ted Daniels doing the good work over here. I also wanted to rewind for you guys, too, about 4 to 5 weeks ago. After Karen Reed got out of her first hearing for the civil trial, the civil lawsuit she's fighting against Peggy, against the O'Keefe family, and a couple of the kids, we're going to hear Alan Jackson talk about this moving forward. And Karen Reed even herself says, we're done playing defense. And that's where the lawsuit comes in. Check this out from Karen Reed and Alan Jackson.
Poor girl. So you're from Walshe and Jackson, right?
I think we're a little offensive during the criminal trial.
How does that work? I
need a fullback.
Y'all didn't even let her get a blocking back. My lord.
Okay, we'll put her down.
Alan, can you help me understand what an affirmative claim is? What an affirmative claim is? It's an affirmative claim against third-party individuals. That's exactly what we intend to bring.
But the idea is to get them combined to save the court time and money.
All the same individuals are involved, so that's exactly right. It's a matter of judicial economy.
Your response to the fact that longer if you do this, you have all these.
Well, of course, because it becomes a bigger case, more voluminous, right? It's a bigger case with more claims, and that's exactly what this case calls for.
How did you determine
the days of Karen Reed being on the defense are over? Ooh. Right? That's what started today.
Ooh, he said the days of Karen Reed being on the defense are over. We're done. And now we finally see it here. Let's go ahead and get into this lawsuit. We're going to read the introduction. We're going to talk about the complaint. I think we all pretty much have an idea of what Karen Reed's going to say here. And she's going to have a lot of evidence to back up her claims. We have Karen Reed officially. Let's give her a round of applause, by the way. Karen Reed's out there winning. She beat this charge, found not guilty of John O'Keefe's murder, and now it is time to fight back. Karen Reed versus Michael Proctor, Tully, Buchanan, Alberts, all of them Alberts, the McCabes, and Brian Higgins, most definitely. Here we go. The introduction. For 3.5 years, the plaintiff Karen Reed was wrongly accused of homicide and subjected to suspicion, arrest, 2 prosecutions, and public condemnation, all resulting from the gross misconduct of the Massachusetts State Police, MSP as they're going to be referred to moving forward, and those working in tandem with the MSP to shield from liability the party or parties responsible for the death of Boston police officer John O'Keefe III. Now, after being acquitted of all the charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for and address the actions of those actually involved in Mr. O'Keefe's death. Oh, man. Taking some shots. And the law enforcement officers who objectively failed to ensure the justice was sought and served in the aftermath of January 29, 2022. Karen Reed did not kill her then boyfriend, John O'Keefe. Rather, in the early mornings of January 29th, Mr. O'Keefe was killed in the defendants Brian and Nicole Albert's home at 34 Fairview Road in Canton. It's going to be referred to as the house moving forward. In an altercation during a late night house party with other defendants, collectively as the house defendants, they'll be referred to after a night of heavy drinking. The house defendants responsible for John O'Keefe's death, some of whom had professional experience with police investigations, concocted a plan immediately after the altercation to avoid culpability and to frame Karen Reed. I want to remind everyone, this is not a criminal case. This is a civil case. And the mountains upon mountains and mountains of evidence we saw while covering this Karen Reed trial is all going to factor into what Karen Reed's saying here. In the civil cases, the burden of proof is not as high. So keep that in mind as well. Rather than call first responders for help, among other actions, the House defendants conducted a Google search for information about how long to die in the cold. Of course, that's brought up. Moved John O'Keefe's body outside and placed him on the Albert's front lawn near the road to make it look like John O'Keefe was hit by a vehicle and that he died in the snow without ever coming into the house that night. John O'Keefe's body remained on the Albert's lawn until Karen Reed found him later in the morning. From the beginning, investigators from the MSP allowed the House defendants to direct the investigation away from themselves and towards Karen Reed. The House defendants were all well-connected, close social group with strong ties to law enforcement. The Alberts are a prominent family in Canton, and the investigating police officers knew them well. The lead investigator for MSP, Michael Proctor, grew up in Canton and resides there to this day. He has been and remains close personal friends with the Albert family. House defendant Brian Albert was a longtime Boston Police Department officer, and House defendant Brian Higgins was an agent with the Bureau of Alcohol, Tobacco, and Firearms Explosives, also known as the ATF. Adhering to the underwritten rule of protecting their own, we call it the blue wall, some call it the blue wall, Proctor and MSP colleagues intentionally disregarded the obvious and compelling evidence tying the House defendants to John O'Keefe's murder. They didn't even go across the street and check on the ring footage. Specifically, John O'Keefe's injuries were consistent with a physical altercation. He had bruises and lacerations on his face and a deep gash on the back of the head, suggesting that he was punched and fell backwards, hitting his head on a rigid surface. He also had a dog bite wounds and scratches on his right forearm. Equally evident, John O'Keefe did not have a single injury consistent with being struck by a vehicle, and Aperture, we know, made sure that was easily seen. Put ACA aside. Aperture did the work for us on that one. Equally evident, he did not have an injury from a vehicle. He did not have any broken bones or even a bruise on his legs, feet, arms, shoulders, or torso, back, ribs, or anywhere below the neck that a medical examiner would otherwise expect to find a person struck and killed by an impact from a 3-ton vehicle. We heard that from Dr. La Posada. We heard it from several medical examiners. And to erase any doubt, the Commonwealth's own medical examiner, here we go, the pathologist who conducted the autopsy for the Commonwealth, concluded that Mr. O'Keefe's body showed no signs of vehicular strike. Despite that, Proctor and others shielded the House defendants by intentionally sidestepping fundamental investigatory procedures. Oh, you mean red Solo cups? That's pretty standard, right? I mean, propelled by the House defendant's false statements, including that Mr. O'Keefe never went into the house, Proctor reported in the text messages just hours into the investigation that the House defendants weren't going to get any ish for this because he, Brian Albert, was a Boston cop, and that Proctor was determined to make the investigation cut and dry by bringing charges against the girl. Indeed, Proctor made his intentions clear in writing, Karen Reed had zero chance of skating. She's effed. This pronouncement was a mere 16 hours after John O'Keefe's body was discovered on the Alberts lawn, and Proctor had not even walked into the house. He had already decided Karen Reed was going to take the fall for this. True to his promise, Proctor and his colleagues did not search the house for blood evidence resulting from the gash on the back of John O'Keefe's head, or for fingerprints, or for DNA evidence. Proctor did not search the house despite the fact that John O'Keefe was discovered without a winter coat, without the hat that several witnesses said he had been wearing that night, and without his left shoe. At Proctor's direction, the house was never processed by a criminalist or even photographed, which is insane. No member of the MSP, including Proctor, set foot inside 34 Fairview for nearly a week. The police did not examine or take evidence from the Alberts German Shepherd that was in the house on January 29th, a dog that had a history of attacking other dogs and people. Neither Proctor nor any MSP troopers conducted physical examinations of the house defendants for evidence of involvement in altercation, such as marks on their hands, knuckles, face, or bruises on their bodies. They did not seize or search house defendants' phones. They conducted only perfunctory, unrecorded conversations with Proctor's friends and acquaintances without any attempt to corroborate their stories. They permitted would-be witnesses to communicate with each other and coordinate with their stories before any formal interviews. The crazy thing about this is some of y'all ever were at a house party in college and you were doing stuff you weren't supposed to do, and somebody called the police or the police showed up. What's the first thing the police are doing? Walking inside the house. They're gonna walk inside the house. They're gonna see what's going on, look around, see if there's any drinks there. And you're gonna tell me that a Boston police officer was murdered and you're not gonna check on the house to see what's going on? Come on, man. They're not gonna win this one. They permitted would-be witnesses to communicate with each other and coordinate their stories before any formal interviews. Peggy was involved in that too. They allowed critical evidence to be manipulated in some instances and outright destroyed in others. In short, by focusing the investigation solely on Mrs. Reed as implicitly directed by the House defendants through the misinterpretations they made to the police, Proctor and his colleagues disregarded and failed to obtain pertinent interviews and other critical evidence from the House defendants that cannot now be recovered or recreated. Proctor also secretly communicated with the Alberts on his personal phone, deliberately back channeling those communications to circumvent his state-issued device and use his sister as a conduit. For instance, on multiple occasions, Proctor disclosed critical and confidential information about the investigation to his sister, who passed that information to her close friend, Julie Albert, Brian Albert's sister-in-law. Julie Albert then passed that same information to the rest of her family and the House of Defendants. Parts of these communications included Julie Albert's promise to buy Proctor a thank you gift for handling that investigation in a manner that intentionally avoided implicating the House defendants and singularly focused on Karen Reed. Proctor then went so far as to manufacture evidence to ensure that Karen Reed, not his friends and fellow law enforcement officers, was blamed for John O'Keefe's death. We remember that he rode around with evidence in his car for weeks. No issue there, right? Yuri said this was handled with integrity, with honesty. What? This included planting evidence at the scene on Mr. O'Keefe's clothes and on Miss Reed's vehicle to support the false narrative that Karen Reed hit John O'Keefe with her car, even though he knew John O'Keefe's injuries were inconsistent with the motor vehicle strike and consistent with a physical altercation and a dog attack. How do these people live with themselves? Far from conducting an objective investigation with integrity, that was intentional. Alan Jackson probably had a part in writing this. Proctor personally sexualized and dehumanized Karen Reed throughout the investigation. Specifically, Proctor's private communications to his high school buddies, sister, and MSP colleagues that he believed would never be discovered, exposed the corruption and bias at the core of MSP's entire investigation. Specifically, only hours into the investigation, in a text chain with 8 of his high school buddies, Proctor stated that Karen Reed is a whack job, you know what, it starts with the C. She's retarded, a nutbag, and a babe with no ass. Dang. I'm not going to say the word. This is a family show. Proctor further ridiculed and derided Karen Reed for her serious medical condition, stating that her balloon knot leaked poo. In other private messages to his MSP supervisors and colleagues, Proctor bragged that while conducting a search of Karen Reed's phone, he was looking for naked pictures of Karen Reed. Disappointed, he reported that there were no nudes so far. In an unfiltered utterance, Proctor revealed his true mindset. He said, hopefully she deletes herself. Yes, he did say this in case you missed it. Indeed, Proctor's supervisors and MSP knew about and condoned Proctor's unlawful conduct, and some instances expressively encouraged this flagrant abuse of power. For example, on one occasion, Proctor's immediate supervisor, Yuri Buchanan, responded with a thumbs up emoji to a text calling Karen Reed retarded. Proctor's supervisors and the MSP knew Proctor had a close relationship with Alberts, and he made no secret of his bias against Karen Reed, demonstrating a clear prejudice against her from the onset, even saying how much he hated Yannetti. Relying on manufactured evidence, actively ignoring exculpatory evidence, and without investigating obvious signs pointing toward the House defendants, the Commonwealth secured 2 separate arrest warrants for Karen Reed and knowingly, baselessly indictment against her, and then wrongfully prosecuted her for murder twice. As alleged below, these lawful acts not only underlie plaintiff's meritless wrongful death claim against Karen Reed, but they also form the foundation for Karen Reed's claims against the defendants. The reason they're bringing this up is because this is a counterclaim to Peggy and John O'Keefe Sr.'s claim, or John O'Keefe II's claim against Karen Reed that she caused wrongful death, because they still believe she caused the death of John O'Keefe. These acts violated Miss Reed's state and federal constitutional rights, the Massachusetts Civil Rights Act, and well-established Massachusetts tort principles. On June 18th of 2025 of this year, after a 2-month trial, a jury rejected the Commonwealth's theory, in part because the overwhelming physical, scientific, and medical evidence established that Mrs. Reed's vehicle did not strike John O'Keefe, and that Mr. O'Keefe, John O'Keefe's injuries did not come from a vehicle strike. Although Karen Reed was ultimately and finally acquitted of all charges related to the death of John O'Keefe, Proctor was fired, and nearly every MSP officer in Proctor's chain of command was disciplined for egregious abuses of misdeeds. The Commonwealth still has not sought or provided justice, not for the O'Keefe family, not for the community at large, and certainly not to Karen Reed. In response, the Commonwealth has offered only empty platitudes instead of solutions. Even their own commissioner says, hey, the case is over. Let's just move on. I'm sorry to the O'Keefe family, but can we move on from this? Why are we still talking about this? The commissioner said that. The head of the MSP, Colonel Jeffrey Noble, stated, the events of the last 3 years have challenged our department on thoroughly review our actions and concrete steps to deliver advanced investigative training, ensure appropriate oversight, and enhance accountability. Under my direction as Colonel, the state police has and will continue to improve in these regards. In an interview with the Boston Herald, Noble acknowledged the systemic nature of the MSP's conduct in Karen Reed's case. I'm eyes wide open to a culture issue that I have concerns with as it relates to Trooper Proctor. These hollow words do nothing to right the devastating wrongs that have been visited on Karen Reed. Colonel Noble's words confess a sick deep in the marrow of the MSP, but offer no remedy, no medicine, no relief to someone who brutally was victimized by it. On Wednesday, March 19th of this year, following the public disclosure of Proctor's illegal and unethical conduct related to Karen Reed's investigation, the MSP trial board found Michael Proctor guilty of a Class A violation, which includes that he was biased in his dealings with the homicide suspect and or brought otherwise himself and the Massachusetts State Police to disrepute. Yeah, that was easy to see. Karen Reed's life was not merely turned upside down by the MSP and the House defendant's misconduct. It was forever changed by the defendant's transgressions and wrongdoing. The years of uncertainty and unimaginable emotional distress have left lasting scars that will never heal. At the same time, neither John O'Keefe nor his family have received justice. It's true. His killer or killers still walk free. By asserting her claims against MSP, Proctor, his supervisors, the town of Canton, and the House defendants, Karen Reed seeks at minimum to confront and readjust the wrongs and others. More importantly, she seeks to force the Commonwealth to fulfill its duty to stop law enforcement from trampling the innocent to protect their own. And that is the introduction by Karen Reed. Well said. We're going to get into a little bit more of this lawsuit in a second. Let me know what y'all think about the introduction. The crazy thing is, the large majority of what's being said in this introduction, we've already seen evidence to. We've heard from Jim McCabe. We've heard from some of the Alberts. We've heard from Proctor. We've heard more than enough from Proctor. We've heard from Higgins. We've heard from Yuri Buchanan. He's somewhere else on desk duty. Proctor's gone. We don't know what's going on with Higgins. The Alberts, who knows what's going on with them? Let me know what y'all think about this in the comments in the chat. This is going to be a wild one. Can't wait to see how it plays out. Thank you to all of y'all who are in the building. Shout out to Amy for dropping the cake, reminding me not only does she have the cakiest cake in the world, but I need to make sure that I feed myself and get some lunch. It's going to happen. Thank you, Amy, for the reminder and for the love. Shout out to my dog, CG Beats, is in the building. The blue tail light. This case won't see a courtroom for years. Yeah, it'll be next year. It'll be next year. They're all cooked. I agree. Let's go through some more of this because there's a lot here. I really just want to go through and look at what's being alleged here. Facts common to all counts. John O'Keefe's death. We know the facts behind that and everybody who's involved. What else do they have? And this is just 46 pages long. We've got Karen Reed searches for John O'Keefe. That was on January 29th. We know what happened there. The investigation begins. We know how that went down. We've got Sergeant Lank was involved. We know Gallagher was involved. Proctor leads MSP investigation despite the conflicts. What else do we have? Proctor, Buchanan, and Tully engaged in corrupt and biased investigation by not investigating inside the house and interviewing house defendants as friends rather than suspects. Weren't they all upstairs in the room and they were just bringing them down one at a time? What did he say? Proctor, Buchanan, Tully, and MSP never searched for DNA evidence inside the house. Insane. Absolutely insane. Never looked for rigid surfaces that could have caused a gash in the back of John O'Keefe's head. Never inspected the house defendants' bodies for indication of bruises, cuts that resulted from an altercation, and did not search the house defendants' cell phones. This allowed potential evidence to be destroyed, disposed of, removed, or simply become unrecoverable. Proctor, Buchanan, and Tully's interviews of the house defendants were also outside of normal protocol. They were all interviewed either at their home, their family member's home, their lawyer's home, in the case of Brian Higgins, their lawyer's office, in the case of Brian Jr. and Caitlin Albert, their place of employment, or over the phone. Well, at least they didn't text it, I guess. These interviews were each ultimately untimely, unrecorded, and fundamentally designed to protect the House defendants, and the House defendants took full advantage of it. Specifically, Jennifer McCabe became the point person for the House defendants in providing the false narrative to investigators. She managed and communicated details about the House defendants' messaging and the investigation itself, including visiting Proctor and other investigators' private residences, mapping out timelines to coordinate statements with other witnesses, leading group text message chains that were later partially deleted, and planning private meetings at all hours of the day and night. Indeed, these were never the acts of innocent witnesses seeking to help an investigation concerning the death of an alleged friend. Rather, they were predicate acts of a conspiracy among a group of people with the shared goal of deflecting the criminal exposure onto someone else. The remaining group texts that were not deleted or that were recovered later reveal some of their planning. For instance, on the evening of January 29th, Jennifer McCabe texted with her sister, Nicole Albert, and that Carrie Roberts, who was present when John O'Keefe's body was found, talk to the cops and keep it simple, she said. Of course, there would be no reason to report back to other House defendants about the Roberts keeping it simple unless what really happened was more complicated. And it says Proctor, Buchanan, and MSP never sought these communications. Rather, they were obtained by Karen Reed's defense attorneys' repeated motions to compel access to data on Mrs. McCabe's iPhone. Later in the group text with Jennifer McCabe, Brian Albert, and Nicole Albert, Matthew McCabe suggests having Chris Albert publicize their crafted story to a reporter, saying, "Ask Chris to ask some questions. Tell them the guy never went into the house." Crazy. As an endorsement of the plan, Brian Albert responded, "Exactly." Imagine all the cloud info that will be downloaded for everyone's phone. Yeah, it's absolutely crazy. There's so much more I could get into on this, and I want to actually read through this whole thing, but I know we would be here forever if I were to read through this. Rather than investigate their friends and brethren, Proctor, Buchanan, Tully, and MSP target Karen Reed. We know how that went down. Proctor and Buchanan plant certain evidence and make false statements in court and other legal documents to frame Karen Reed. I can guarantee that Sergeant Barrows is going to be brought back to testify in this trial, because the car was a key factor into this whole thing, especially the taillight. Other aspects of conflicted and corrupt investigation. We've got all that. What else do we have? The indictments, trials, and the aftermath. Absolute mess. MSP investigates and pushes Proctor, Buchanan, and Tully punishes Proctor, Buchanan, and Tully for their misconduct during the investigation. And then here are the counts. All right, this is the important. Malicious prosecution under the Fourth Amendment against Proctor, Buchanan, and Tully. No good here. We've also got supervisor liability against Buchanan and Tully. Thumbs upping messages that were obviously prejudicial. Conspiracy to deprive Karen Reed of her Fourth Amendment rights. And this is by Proctor, Buchanan, Tully, the Alberts, the McCabes, and Higgins. So basically everybody. We've got Massachusetts Civil Rights Act. That's against almost everybody. No, it is against everybody. Common law malicious prosecution. We've got intentional infliction of emotional distress. Proctor is definitely going to be found guilty of that one. And probably a lot of them. Proctor, Buchanan, and Tully, everyone, civil conspiracy. We've got, what else do we have in here? And then we've got the prayer for relief. What is Karen Reed saying? Wherefore, Miss Reed, Karen Reed respectfully requests enter a judgment in her favor against each relevant defendant on each of the counts of the complaints, award her damages in the amount to be, okay, so she wants the judge to decide. She wants her attorney's fees and all the other fees. Shocker here. I know you guys are surprised at this. Alan Jackson signed this thing. And of course, Damon's in there too. Shout out to Damon. This is going to be fun. And it's sad, you know, I keep saying this because I think this gets missed a lot in the hype and the drama of Karen Read. This John O'Keefe, we still don't know and possibly will never know what happened to him. And that's the saddest thing to me. This man lost his life. And the person who did it so far has gotten away with it. The Honorable Attorney Kel Bell says the amount of money these folks will have to pay attorneys to defend this is crazy. Do you guys think someone's going to break? If so, who's going to be? We talked about it when we watched the interview of all of the McCabe's and the Alberts up there crying about, oh, we're the victims. We're the ones that suffered. We've been harassed. We've been mistreated. It's been so unfair. And we looked at, every one of them up there crying. And we said, man, I personally think somebody's going to break and just going to spill the beans. Who do y'all think? Do y'all think they're going to stand firm? They made it this far. Jen McCabe's going to say they're not going to back down now. Or somebody's going to break. I take satisfaction that the McAlberts have to pay for attorneys. Yeah, as they should. As they absolutely should. I mean, this entire thing is insane. All right, let's go ahead and get this one in here because we got to talk about what's going on with the other side. Speaking of the other side, we're not done talking about them yet because, yes, there have been rumors that the people we just mentioned are going to file another lawsuit against Karen Read. So let's get into it. We've talked about the Alberts, we talked about the McCabe's, and we talked about what's going on with Karen Read. As many of you know, Karen Read officially filed her first lawsuit, and she mentioned Brian Higgins, she mentioned the McCabe's, the Alberts, Yuri Buchanan, Proctor, obviously, and Brian Tully. But we're also hearing reports that a defamation lawsuit is going to be filed against Karen Read, another lawsuit, because I guess the Alberts and the McCabe's are upset at what Karen Read is saying and what her and Turtle Boy did. Turtle Boy is going to be involved in this as well. Check this out from WCVB in Boston.
Karen Read will soon be facing another lawsuit.
Yes, several witnesses from Read's trial plan to sue her for defamation. Our David Bieniek is live in Canton with this. David.
Good afternoon, Jessica. Yes, Karen Read was already facing one lawsuit for wrongful death filed by the family of John O'Keefe. Now, 5 witnesses from Read's criminal trial say they plan to sue her and Aiden Carney, the blogger known as Turtle Boy, for defamation. Those witnesses are Jen and Matt McCabe, Brian and Cole Albert, and Brian Higgins.
And this is the exact interview I'm talking about. This is the one right here. This is the one right here. Shout out to Miss Albert.
As part of Read's defense during the criminal trial, she claimed that the McCabe's, the Alberts, and Higgins are the ones really responsible for the death of John O'Keefe and that they tried to frame her to cover it up. In a new legal brief, the witnesses call that a, quote, vile work of fiction that they say Read concocted to evade responsibility for her actions. The defamation case against Read and Carney has not been filed, and the brief gives no indication when that might happen. In response, Read's lawyer tells me truth is an absolute defense to a claim of defamation. He says, we will defend Karen Read vigorously against such baseless claims. Read was found not guilty of murder and manslaughter earlier this year. The civil case is due to return to court on Friday. In Canton, David Bieniek, WCVB News Center 5.
All right, so let's check out this article from Boston 30. What did they say? Karen Read case, the Alberts and McCabe's, Higgins eyeing a defamation claims against Karen Read and Turtle Boy. This battle is going to go back and forth for forever. I guarantee well into 2027, this won't be settled in the next year, within the next 12 months. I promise you. Karen Read's case. The witnesses from Read's high-profile murder case are denouncing her cover-up claims as vile and a work of fiction. Still hounded by conspiracy theories months after Karen Read's acquittal, several witnesses from the high-profile murder case are denouncing Karen Read's cover-up claims as a vile work of fiction. Really? The outlandish frame job allegations were a part of Karen Read's scheme to defame and wrongfully malign prosecution witnesses and evade responsibility for the death of her boyfriend, John O'Keefe. Lawyers for Brian and Nicole Albert, Jennifer and Matthew McCabe, and Brian Higgins argue in a new brief recently served on Karen Read's legal team. I mean, we saw the evidence, guys. We heard the testimonies. You can't fool us. We are not fooled. Very few people believe that someone else was involved in this and that Karen Read is still guilty. I don't know what we're talking about here, but we'll hear them out for a second. All 5 witnesses attended an ill-fated after party at the Alberts home in Canton, where John O'Keefe was badly wounded and found in the snow on January 29th of 2022. Prosecutors alleged that Karen Read drunkenly backed her SUV into John O'Keefe while dropping him off at the gathering, but she claimed investigators and the after party guests conspired to frame her. In June, a jury found Karen Read not guilty of her most serious charges, convicting her only of drunk driving, which is a misdemeanor. However, Read's legal saga is far from over. She still faces a wrongful death suit from the O'Keefe's relative, who maintained Karen Read was to blame for killing the Boston police officer. They won't let it go. During a September hearing in the civil case, Karen Read's lawyers announced her plans to bring legal action against several witnesses and Massachusetts State Police investigators, further complicating the proceedings. Read is seeking to combine her conspiracy and civil rights claims with the wrongful death suit for efficiency's sake, but a judge has yet to rule on the request. The Alberts and the McCabe's and Higgins are asking that Read's motion be denied and her claims be filed in a separate case. The Commonwealth's witnesses vigorously dispute defendant Read's allegations and will defend against these false claims, the lawyers explained. They said that their defense will include motions to dismiss, a potential request to move the claims to federal court, which is going to be huge, and counterclaims against both Read and Turtle Boy blogger Aidan Kearney for defamation and other torts that have committed individually and in concert. A staunch supporter of Karen Read's innocence, Turtle Boy racked up several criminal charges after he was accused of intimidating witnesses in this case, or as TB says, he hurt somebody's feelings, including the Alberts and the McCabe's. Authorities later alleged Read's leaked non-public information to Turtle Boy, though she never was charged with witness intimidation. Meanwhile, Turtle Boy maintains his actions were protected under free speech. I agree. Lawyers for the Alberts, McCabe's, and Higgins said they plan to seek justice in a separate motion over allegations that Read and Kearney's defamed and substantially injured them through a myriad of false statements. We saw the evidence, guys. I don't know anything that Turtle Boy has said is false when it comes to this case. Combining those defendants' claims or those defamation claims with Read's conspiracy claims and the O'Keefe's wrongful death suit is procedurally improper at this stage and will make for a much more sprawling case, the lawyers argue. Reach for comment on the potential defamation claims. Read's defense attorneys, Damon S., via email said, and now we know that they filed a claim, the truth is an absolute defense to the claim of defamation, and we will defend Karen Read vigorously against such baseless claims. And again, it's funny to see here that the Alberts and the McCabe's, they're threatening, they're saying, oh yeah, we're going to do this, we're going to go after you guys. They haven't filed anything yet. Now we see Karen Read saying, hey, I've got the evidence. I've got everything that I need. This lawsuit is going down and it's here. And I want to read something that I saw from Aidan earlier today in reference to Brian Walshe, which is interesting. He said Brian Walshe is pleading guilty to disposing of a body, but not murder. And I'll put this up here for y'all so you can see it. He said it's undeniable now that Anna Walshe is dead. This should be an interesting defense at trial. By admitting to this, he faces less time in jail than I am for hurting Jen McCabe's feelings. Isn't that crazy? He also said something I thought was interesting too, which I mentioned earlier. And what does he say? He's commenting on this lawsuit that was allegedly going to be filed by the McCabe's and the Alberts. And now that Karen Reed filed this claim, TB says this, see this? This is how an announcement about lawsuits are supposed to happen. You don't announce that you might be filing a lawsuit in the future. You file the lawsuit and then you announce it. We know clearly and we've seen clearly that this group, we'll call them the House, the House defendants, are playing a lot of games here. Turtle Boy said in an email that he has not been served by anyone involved in Karen Reed's case. He cited Jennifer McCabe's heavily debated House Lawn to Die in the Cold Google search and testimony from other witnesses in Karen Reed's criminal trial, including defense's crash reconstruction expert who said John O'Keefe's injuries were consistent or inconsistent with having been struck by Reed's SUV, and a defense dog bite expert who opined that John O'Keefe had been wounded in a dog attack. Turtle Boy also pointed to several witnesses who denied seeing John O'Keefe's body on the Alberts front lawn early in the morning of January 29th, a group that included Brian Higgins and the McCabe's. Given that the evidence, he alleged, the only logical conclusion a reasonable person could reach is what I have been saying for the last year plus. The people inside Brian Albert's house murdered John O'Keefe. He is not backing down. The only reason they have not been arrested or treated as suspects is due to the corruption and incompetence of the Canton and state police, many of whom had direct ties to the Albert family, Turtle Boy wrote. Pointing out these facts is not defamation. They are free to sue me and bring this to trial, as I would be more than happy to keep their crimes in the public eye as long or as much as possible, and to explain these facts to a jury and let them decide who they think killed John O'Keefe. Notably absent from the opposition brief is Brian and Nicole Albert's nephew, Colin Albert. A lot was said about Colin Albert in the past. Maybe he was upset or he was in a fight or an argument with John O'Keefe because we saw the injuries, and Amy posted this over on her ex as well, that Colin Albert, shortly after this went down, was shown or pictured having injuries, bruises to his face, a black eye even, and he wasn't mentioned here at all. But notably absent from the opposition brief is Brian and Nicole Albert's nephew, Colin Albert, who was also present at 34 Fairview Road the night John O'Keefe died. While Reed previously sought to implicate Colin Albert in her third-party culprit theory, she has not named him in her civil conspiracy claims. The wrongful death lawsuit is due back in court this Friday. All right, so let me know what y'all think about this in the comments in the chat. We have no lawsuit from the other side yet. I think they're just doing what they've been doing, and that's talking. So we'll see if anything comes of all this talking by the other side. I want to know what y'all think in the comments in the chat. I had a couple other topics I wanted to get to today, but man, this Karen Reed thing is going crazy. Brian Walshe, Karen Reed, Higgins, Alberts, McCabe's. It's wild out here. Cat Not Williams is in the building. Good to see you in here, Cat. We've also got a super chat from Mary. Says, thank you for all you do. And Amy. Yeah, shout out to Amy. She's the real brains behind the operation. I'll just be up here talking. Said House of Cards, House of Defendants. Yeah, why do they call them House Defendants? It sounds kind of funny. Laugh out loud. The House Defendants. How does he make that so funny? Oh man! Shout out to the House Defendants. We've also got Amy says, "How long this case keep going? Keep making other cases or lawsuits." Amy, we are going to be here possibly until 2028. As a content creator, I'm not mad. I'm not mad about it. The one thing I think I'm going to continue to keep saying is justice for John O'Keefe. Karen Reed had her turn twice. She's out of the question. Not guilty. We need to figure out what happened to this man. We have to. It's just like Shamel Drink's case from YSL. Super sad. We will probably never know who was the actual killer. That's so true. Rest in peace to Shamel Drinks, man. Very, very sad. I take satisfaction that the McAlberts have to pay for attorneys. Yes. Shout out to Melly showing love again. Became a new member. Thank you for the love today, Melly. I appreciate you. Make sure you check out the members only content over there. And we got a ton of videos we're going to be dropping today. You get instant access to those videos as well. Don't have to wait until they're scheduled and published. So if y'all haven't checked out the memberships, make sure you do that. Shout out to Cat Not Williams. If y'all haven't yet, please make sure you go support Cat Not Williams. Watch her content over there as well. She's been talking about a lot of stuff, posting on X2 on what's going on with Relly, ASAP Relly. Shout out to Relly. We might get into that at some point, maybe tomorrow. I want to give again a big shout out and thank you to everyone that liked the video. There's 13,000 of y'all in here, and most of you have liked the video. If you haven't yet, please like the video on your way out. Likes are free. They help the channel out a ton. Also, big thank you to everyone that went the extra mile and sent in the super chat. As I just said, shout out to the one girl, or that one girl, Melly, in the building, showing some love. Shout out to Mary, and of course, my awesome, amazing Amy, the beautiful Amy Ian here. We will be back tomorrow, y'all. I had so many topics I wanted to get into today. We're going to push some of them tomorrow. So make sure if you haven't yet, subscribe, hit the notification bell so you don't miss any time that we go live or drop a new video. I will be back here tomorrow giving y'all some more updates, and I'm sure we'll have some news about Brian Walsh, even maybe about Karen Reed. And Turtle Boy, I know, is going to have something to say about this too. Hope y'all have a great rest of your day. As always, you know what to do. Keep growing, keep pushing, keep it classy. We go. Peace. Y'all are amazing, man.